Hello again and welcome back. Attorney Andrew Bethel of Bethel Law, where we dive deep into estate planning, finances, real estate, and taxes. Today we're unpacking something I've spoken about before, California's Revocable Transfer on Death Deed, or a TOD deed. Way back in the before times of June 2022, I did a video on Revocable Transfer on Death Deed since we had some new regulations that came out that year. And by that time, it appeared that these deeds were destined to stay since they were relatively new in California at the time. Now that it's been a few years and we've successfully established a lot of them, I figured it was a good time to revisit transfer on death deeds and regulations and share what we've learned by practice. Before we get into it, don't forget to like and subscribe and share the video with someone you know who owns property in California, and let's dive in. First up, what exactly is a revocable transfer on death deed? Often abbreviated as TOD Deed, this document allows property owners, like yourself, to pass down residential property upon death directly to a designated beneficiary, bypassing the lengthy and costly probate process. However, it's not without its nuances and limitations. As time has progressed since their inception in 2016, the process for executing a TOD deed has become more stringent, I'll say. The deed must now be signed in front of two disinterested witnesses who can attest that they either observed you signing the deed or heard you acknowledge that the signature was yours. This is in addition to the requirement that your signature be notarized. Going further, once that deed has been signed by you and the disinterested witnesses, and your signature has been notarized, the TOD deed must be recorded within 60 days. Failure to do so will result in the TOD deed being considered invalid, and you'll have to do the whole thing all over again. Here's how these deeds work. Suppose you own a residential property, be a single-family home, a condo, or a small agricultural property under 40 acres. You decide who you want to inherit this property after your passing. With the TOD deed, you can name any person, a trust, or even a legal entity as a beneficiary. However, it's crucial to understand the intricacies involved. As I've already mentioned, errors in fulfilling the exact requirements can completely void the TOD deed. Plus, if there's existing debt on the property like a mortgage, those debts don't vanish. Your beneficiaries would inherit not just the property, but also the debt, complicating what might seem like a straightforward transfer. Now, this would also be the case if your beneficiary inherited the property either through a trust or probate. However, where the TOD deed differs from those processes is that your beneficiary under a TOD deed also inherits your unsecured debt like your credit card bill. Your secured debt is debt backed by the house like your mortgage. Don't pay your mortgage, you might lose your home due to a foreclosure. This debt generally goes along with the property securing it. Conversely, your unsecured debt is debt that's not guaranteed by anything like most credit cards. You don't pay back American Express or Capital One, your credit will tank, but they can't touch your house. If your beneficiary receives your property by a TOD deed, then they take that unpaid American Express bill along with them. On a quick side note, we have long-term care programs like Medicare or Medi-Cal here in California. If you receive assistance from one of these programs and you die, then the government is obligated to seek a recovery claim against your estate for the state's cost during your lifetime. However, for us here in California, we can avoid this recovery claim by ensuring our estates avoid probate, which we typically do by creating a trust. However, revocable transfer on death deeds also avoid probate. How does a transfer on death deed work with Medi-Cal and long-term care here in California? Well, you have to subscribe and watch our upcoming video all on Medi-Cal recovery claims in California to find out. Coming back to TOD deeds and some potential pitfalls, limitations, and risks, we have your designated beneficiary. If a designated beneficiary predeceases you, their share does not transfer to their heirs, but rather is redistributed among the surviving beneficiaries. If no beneficiaries survive, your estate will end up in probate, which defeats the purpose of the TOD deed in the first place. Let me make that clear. Revocable transfer on death deeds do not allow for contingency planning or even conditions. You pick 3 beneficiaries, the property goes equally between the 3 as tenants in common, meaning no right of survivorship. If one of those beneficiaries dies before you, then the property goes equally between the remaining 2 and so on. Plus, once the property is in those beneficiaries' hands, they need to do something with their portion. Otherwise, their estates will wind up in probate court for their portion of the property. Furthermore, complications arise with title companies, which may be hesitant to issue title insurance for up to 3 years post-death due to the potential challenges to the deed. What this means is if you inherited a property from mom through a TOD deed, you might not be able to sell the property, at least not easily or at fair market value, for many years. This means you're stuck with the ongoing maintenance, upkeep, and costs of owning that property. The real killer will likely be property taxes after the county assessor's office reassesses the property taxes from mom's date of death onwards. I've got an excellent video that can teach you everything you could ever want to know about property taxes in California linked in the corner, so check that out after this video for details there. Now, despite these potential headaches, the TOD deed can be an attractive option for those seeking a simple, cost-effective alternative to more complex trust structures or the traditional probate process. It avoids probate if all conditions are met correctly, is revocable at any time during your lifetime, and carries the same tax advantages as if the property were transferred via a trust or will from a capital gains tax perspective. However, considering the strict requirements and the risks of mishandling, it's crucial to strategize carefully. This deed can be a useful tool in your estate planning arsenal, especially if you anticipate no complications with beneficiaries and are confident in the stability of your decisions. Another point to keep in mind is, what if we have two people who own a property as joint tenants, such as a married couple, and they each execute their own revocable transfer on death deeds? What wins out? The right of survivorship inherent to joint tenant titling, or the TOD deed? Drop a comment below on which one you think it is before I tell you the answer. Joint tenancy or TOD deed? All right, locked in your answer? The joint tenant titling will take priority over a TOD deed even where the TOD deed was executed later in time than when the property was placed in joint tenancy. Thus, if Ned and Catalin hold a property that's, let's say, Whiteacre as joint tenants, but each later executes a TOD deed giving the property to different people, say John for Ned and Rob for Catalin, then whether John or Rob inherits the property depends on who outlives the other between Ned and Catalin. If Ned dies first, then his portion of Whiteacre goes to Catalin, where upon Catalin's death, Rob will inherit all of Whiteacre and John receives nothing. Whereas the opposite would happen if Catalin died before Ned. Of course, if both Ned and Catalin both pick the same person as beneficiaries, then it doesn't matter who dies first, only that there are some beneficiaries living by the time both Ned and Catalin die. One last point you should keep in mind, but which I won't dwell on too long here, and instead we'll discuss in a video all on its own, is the fact that, like a will, a revocable transfer on death deed is just simply not robust or flexible as a revocable living trust is. In that vein, I want to call your attention to just one aspect of that: incapacity during lifetime. More specifically, your incapacity. If you were to become incapacitated in any way, but you are still alive, then having a TOD deed does nothing to help you or your family. If that property needs to be sold or rented out, and you did not have any estate planning done aside from the otherwise valid TOD deed, then your family may have to go to a court to do anything with the property, and thus defeats the purpose of saving money in the first place, not to mention the complete loss of privacy as a result. Anyway, I'll discuss that in a video very soon on what a trust can do for you during your lifetime. In wrapping up, the revocable transfer on death deed might not be for everyone, but it could be the right tool for you depending upon your circumstances. Do you think the TOD deed fits your estate planning needs, or do you find it too risky given its potential complications? Drop your thoughts and questions down in the comments. I look forward to hearing from you. Remember to like, subscribe, and share the video with someone who needs to stop procrastinating and plan their estate. I'm attorney Andrew Bethel, and I look forward to seeing you at our next meeting.